Welcome back, everybody, to the Legal History Project for the Law Academy. Now, this first video, or at least the first substantive video in the topic of Roman law, is going to spend a few lessons, essentially. The first major topic, at least, is going to spend a few lessons talking about the history of Rome. We're not going to go into any particularly great detail looking at the very specific details of the Roman Empire, the Roman Republic, early Rome, etc., but just generally provide an overview of the historical aspects of the topic that we're even talking about. Because it's not like the history of English law, where, for those of you who are studying English law, you might have an understanding of the history of England already. You might have a basic understanding of the Norman conquests, the Anglo-Saxons, Magna Carta, the Tudors, or whatever. The Roman Empire and the history of Rome is a little bit more removed from ordinary history understandings. Most people who study history in the UK, for example, don't do that much looking at the Romans, maybe look at Romans in Britain, but not much of the Romans in and of itself. So I want to spend 2 or 3 or 4 lessons looking. I can actually tell you exactly how many lessons it will be. It will be 4 lessons looking at early Rome, the Roman Republic, the Roman Empire, and then post-classical Rome, which is, of course, the idea of Byzantium, which takes place from around 476 CE to 1453. So that's what we're going to explore. And we're going to begin by looking at early Rome. Early Rome is sort of generally defined as a period between 753 to 509 BCE. Now, it is traditionally shrouded in legend and myth, but it is still nevertheless a critical phase in the development of Roman law and the Roman legal institutions. And so while we'll be doing a basic historical overview in this lesson and in the next few lessons, we will also do so with the idea of the law and institutions and legal institutions in mind. So, the period of early Rome is an era that encompasses the founding of Rome in 753 BCE to the establishment of the Roman Republic, which takes place in 509 BCE. And it marks a transition from small tribal settlement to a more organised society with the early foundations of a legal order, the legal order that we'll explore in future videos. So, beginning first then, let's have a look at the basic political and social structure of the early Rome period. Now, from a foundational perspective, according to Roman legend, we see that Rome itself was founded in 753 BC by Romulus and Remus, the twin sons of the god Mars and the priestess Rhea Silvia. Of course, there is a certain sense of mythology imbued within this founding. Initially, the Romans established themselves as a monarchy. Rome's first 7 kings were said to have shaped the city's early institutions. These early institutions included the religious, military, and legal practices. Now, of course, you can't really think about Roman mythology without reference to Greek mythology. You'll notice that for those of you who are wanting to dive a bit deeper into Roman mythology, you might think that there are very clear comparisons between the gods in Roman mythology and the gods and the goddesses in Greek mythology. Mars and Ares, for example, both being the god of war, and you can see other examples. People like I believe Zeus and Jupiter being similar as well. Now, during this early period, then we can see that the kings of Rome were central to the legal system in this early period. Their duties included not only the making of laws and the administrating of justice, but also the overseeing of religious rituals and military decisions. And so Roman kings exercised a sense of absolute authority over a number of legal matters, and their decisions were often guided by the belief that kings were divinely appointed, which then lent their decrees and judgments significant legitimacy. if you wanted to do a sort of interdisciplinary link between Roman law, as we're studying here, and the history of English law that we've done in the Legal History Project previously, you might see that link in the idea of the divine right of kings. The divine right of kings from an English law perspective comes, of course, from the Christian God, whereas during this period we still have a similar sense of the divine right to rule, the divine right of appointment, which lends the decisions of a king to have legitimacy. The legal system itself was highly personalised. The king played a very key role in resolving disputes and enforcing social order, often relying on something known as the mos maiorum, the customary law, rather than having any kind of codified legal texts. The codification of legal text is something that we will see later on in the Roman period. But for now, though, we'll continue thinking about early Rome. Early Rome was generally divided into several different groups of political and social organization. The noble elite class were known as the patricians, and they held the most power, including both political and also religious authority. They were believed to be the descendants of Rome's earliest settlers, as well as Rome's priestly families. The plebeians were the common people, and they were typically described as farmers or labourers or artisans. Now, initially, the plebeians had very little political influence and no real direct participation in the legal system. So the period of Rome that we're studying here at the moment would define the plebeians as having very little direct participation. And then finally, we can't really focus on really any of the Roman Empire without looking at the role, the integral role that slaves and slavery brought to early Roman society. Of course, slaves had no legal rights, and they were subject to the authority of their masters. Basic, as simple as that, really. But also, within this whole kind of political and social organization, there was a sort of patronage system that existed, where you had the patron, often a wealthy patrician, providing protection and assistance to their clients. And the clients would often be lower status individuals, so more likely than not plebeians. And so we can see that the idea of a relationship between clients and patrons begins to exist. And this kind of system is essentially providing from one side to another protection and assistance to their clients in exchange for loyalty and service. And if you want to make sort of legal comparisons and legal linkages, you can see that this idea of the patronage system reflects very commonly the idea of the contract, the idea of the basic principle of the contract, the agreement for something else, the idea of consideration within the contract, the exchange of promises, the idea of the patron providing protection in exchange for loyalty and service. So what did early Roman law look like? That's a basic overview of early Rome. What did the early Roman law look like? Well, early Roman law, as I mentioned already, was characterized as a system which was customary in nature, the mos maiorum. The idea here was that there was no formal written law. Instead, legal norms were based on unwritten customs and traditions that would be passed down through generations. The mos maiorum, the Latin phrase itself, translates to the custom of the ancestors. Now, these customary laws were seen as practical guidelines for managing the relationships between individuals and the broader community, but they would also be deeply intertwined with the mythological and religious beliefs and values that the Roman society was beginning to imbue. The idea of the customary law governed a number of certain areas. So, for example, the head of the family was the individual who had supreme authority over all other members. This included the power of life and death over his children and his slaves. And the customary law ensured that this was a principle that was enshrined. So the family and the household was one area where the customary law prevailed over anything else. An area such as honour and reputation, the idea of social status, was something that was governed by customary laws. Violations of very social norms, such as insults or breaches in etiquette, could result in legal disputes, often leading to family feuds or even sometimes public trials. And then finally, the ownership and possession of property were key concerns, and the customary law governed how property was to be transferred, how it was to be inherited, and how it was to be protected during this period. In early Rome lawmaking as well, the king, of course, had a very significant role. The king had the authority to create laws. These were often considered to be divinely inspired, or at the very least accepted as legitimate by the populace. There was no formal legislative body, there was no elected assemblies at the time, and so the king's word outside of the custom was law. The king, along with his council of advisors, would also make judicial decisions. So they would essentially pass favour on those who were involved in serious crimes, either or maybe even property disputes or even sometimes civil matters. Many of these laws were based, again, on the moral, religious, and mythical codes of practice, such as things like the prohibition against sacrilege or the dishonouring against the gods. These were the kinds of rules that were deeply imbued with this kind of sense of religious and mythological fervour. Early legal decisions and laws would be made on a case-by-case basis, so the idea of precedent wasn't necessarily something that existed in any formal or meaningful sense. Instead, the king would just interpret and apply the law in the interests of either themselves or, where it is a particularly benevolent king, social cohesion, the interests of social cohesion. The legal process was very informal then. There was no institutionalized system of legal reasoning or procedures. There was no doctrine of precedent. Things would just be managed on a case-by-case basis. I've mentioned already that a lot of these laws, whether it be the customary law or the decrees that were passed down by the early Roman kings, had imbued deeply within them a sense of religious or mythological fervour. And so, with that in mind, it's important to remember that religious authorities and the role of priests were also very important during this period. The idea of religious authority and legal authority were actually very closely intertwined in early Roman history. The king was also the chief priest, sometimes known as the Pontifex Maximus, and his decisions were heavily influenced by religious customs. Those who operated underneath the Pontifex Maximus were the pontiffs, and they were responsible for advising the king on legal matters. And these were the legal matters that had religious dimensions. So legal matters including sacrificial rites, temple duties, and family rituals. These priests often had the power to interpret the laws concerning religious practices and social conduct. And so it goes as no surprise then that one of the major components of early Roman law was the idea of the religious law. And so the king's edicts were often inextricably linked to the maintenance of the favour of the gods. Violations of the religious law then would result in, or could result in, should I say, penalties, including exile, banishment, or even the capital punishment, the idea of death as well. So the intertwining of the religious and the legal was something that existed with a great degree of mixing during this period of time, and it reflects quite similar some of the things that we start to see in the development of the civil law traditions after the Roman Empire. So you could make a comparison then, if we're doing another interdisciplinary link, you could make a comparison between the religious law within early Rome and the idea of the canon law in the Catholic Church, and the development of the fact that the church was considered to be one area in which certain legal decisions that concerned either churchgoers or people who were involved in the church or religious matters would therefore be under their jurisdiction rather than the jurisdiction of anything else. With all this in mind then, How did the early Roman legal institutions begin to develop over time? Well, although Rome was ruled by kings in the early period, a group of advisors that became known as the Senate, often composed of very wealthy, very influential men, began to exert considerable influence on legal and political decisions. Now, the Senate at this period of time was not a legislative body in the modern sense. It was simply just an advisory council to the king. And so while the Senate's role during early Rome was largely consultative, it also helped to shape policies, including legal matters, and it also represented the interests of the ruling patrician class. Now, the idea of the Senate and the concept of the Senate would develop throughout the Roman law, and we'll get to that as we start looking at the Roman Republic in future lessons. But just to note at this very early time, this idea of the Senate was just simply an advisory council to the king. It was not the same kind of thing that we start to see in future lessons, and it's certainly not the same kind of thing that we see, for example, in the US today, the US Senate, for example. The Comitia Curatia was the early assembly of Roman citizens. These were organized by tribal groups known as the curiae, and this can sometimes just be translated as the assembly of the people. This assembly, although again having limited power during the period of the monarchy, was involved in confirming the king's decisions, particularly when it came to things like the election of new kings and the ratification of laws. And so within this sort of early legal institutional development, the Comitia Curatia would also have the role of passing laws and making declarations of war or peace. Although, like with the Senate and the advisory councils, the Comitia Curatia was more ceremonial, and again during this time very, very advisory. Concepts of justice in early Rome were largely decentralized and heavily personal. It was often up to the family or the injured party to seek restitution or revenge, the idea of vendetta. It was a practice that led quite a lot to social instability, as you can probably imagine. Roman law began to gradually introduce more and more mechanisms then that would begin to resolve disputes more formally. This included things like trials presided over by the king or appointed judges, although legal procedures remained still very rudimentary. Punishments were often very severe and would often include physical penalties such as fines or banishments, and in the cases of serious crimes, the death penalty would be imposed. Early punishments for crimes such as theft, murder, or treason were harsh and would include things like execution or the confiscation of property. Now, we're going to examine the transition into the Republic later on, but just as a basic overview here, the end of monarchy takes place in a number of stages. So the monarchy in Rome came to an end in 509 BCE, when the last king, Tarquin the Proud, was overthrown following the rape of Lucentia, a noblewoman. Or Lucretia, shall I say, a noblewoman. Her tragic death catalyzed a rebellion among a number of Roman aristocrats, leading to the expulsion of the monarchy. Now, the overthrow of the king marks a very pivotal moment, not just in Roman history, and for those of you who are studying classics or studying ancient history, you might find very, very important, but it also was very important for the establishment of the Roman Republic, where power was then vested in elected magistrates and political officers. This was then the beginning of a more formalized system of law that begins to develop the Roman legal tradition. After the monarchy falls then, the Roman Republic introduces a new system of governance and legal structure, like I said, including things like elected magistrates, such as consuls and tribunes, as well as assemblies and the Senate. Now, arguably the most important shift was the creation of written laws. The 12 tables, for example, of 451 to 450 BCE began one of the most important and major steps in developing legal texts in Roman history. Now, we'll get to the 12 tables, as I've mentioned in future lessons, but the 12 tables fundamentally codifies many of the practices that had been part of early Roman customary law, but most importantly, provides a consistent, predictable legal framework. And so the development of legal institutions begins to take shape, really following the rise of the Roman Republic and the establishment of the 12 Tables. Now, it is for that reason that some of these textbooks and some of these citations, especially Stein's Roman Law and European History, basically begins with the 12 Tables. But I wanted to just spend a little bit of time talking about the early period of Rome and looking at the way in which the legal system starts to develop. And so the next lesson will spend more time looking at the Roman Republic from 509 to 27 BCE, looking at the basic political structure and legal governance, examining the ways in which it began to develop, the importance of the 12 Tables, before then looking at the legal institutions of the Roman Empire and then the Byzantine Empire, before moving on to topic number 2, which concerns the sources of Roman law, which we'll get to in more detail.